my cell phone.
Yep.
The broadcast is now starting. All attendees are in listen-only mode.
Good afternoon. I'm Amy Quackenboss, the Deputy Executive Director of the American Bankruptcy Institute. I'm pleased to welcome you to the next webinar in our ABI-Live series. Today's webinar, which is hosted by ABI's Asset Sales Committee, is entitled Key Issues Regarding Bidding Procedures. Today's webinar will provide an overview of the key provisions in and frequent disputes regarding bidding procedure orders and bidding procedures. The webinar will also address recent trends in this area of the law. Before I introduce you to the panel of speakers today, I'd like to address a couple of housekeeping matters. If you need CLE, please make sure you are recording the CLE codes that will appear on your screen throughout the program. Also during the webinar, if you have questions for the panelists, please type them into the GoToWebinar conversation box on the right of your screen. These questions will be sent directly to our panelists. I am now pleased to introduce today's panel. Our first speaker is Evelyn Meltzer. Evelyn is a partner in the Corporate Restructuring and Bankruptcy Practice Group of Pepper Hamilton in Wilmington, Delaware. She focuses her practice on corporate restructuring, bankruptcy, and creditors' rights. Evelyn has significant experience representing debtors, creditors' committees, asset purchasers, landlords, liquidating and litigation trusts, assignee in assignments for the benefit of creditors, receivers, secured and unsecured creditors, and shareholders in bankruptcy proceedings. Additionally, she acts as counsel for both plaintiffs and defendants in bankruptcy-related litigation matters. Our next panelist is Lisa Vandestieg, who is a partner with Sugar, Felsenthal, Grace, and Hammer in Chicago. Lisa's practice is focused on risk identification and mitigation for her clients, primarily in the areas of bankruptcy and restructuring, business continuity, and business tort and privacy and data security. She has experience in nearly every facet of commercial bankruptcy and restructuring, having represented debtors, secured creditors, unsecured creditors, and unsecured creditors committees. Lisa will also be honored at ABI's upcoming Winter Leadership Conference as a member of ABI's inaugural 40 Under 40 class. And as I learned firsthand last week, Lisa is a wonderful event planner and fundraiser as she planned a very successful dinner in Chicago to raise money for the ABI endowment. Our final expert is James Wright III. James is a partner in the Boston office of K&L Gates, where he's a member of the Restructuring and Insolvency Practice Group. He focuses his practice on representing corporations, bondholders, private equity funds, hedge funds, institutional investors, and other interested parties in corporate restructurings both in and out of court, with an emphasis on large Chapter 11 cases. James has represented clients in a variety of matters, including representing debtors in standalone reorganization, sales of assets, and liquidations in Chapter 11, corporations, private equity funds, and hedge funds as stalking horse and competing bidders in Section 363 asset sales, and various creditors in adversary proceedings and contested matters regarding claim allowance, set-off rights, and plan confirmation. Thank you to each of you for being with us today, and Evelyn, I'll turn the program over to you to begin.
Thank you very much. I did want to take 1 minute and just do one more housekeeping matter before we actually turn to the presentation. As was noted, this presentation is being done in conjunction with the ABI Asset Sales Committee. There was an article that was written for the third quarter 2017 newsletter for that committee on key issues in bidding procedures, and this webinar is a follow-up for that publication. If you're not a member of the Asset Sales Committee, we encourage you to join by going to the ABI website under membership tab, click on committees, select asset sales, and then you can join our committee. So with that, I just wanted to take a moment and kind of go over what we're going to discuss today. So if you want to go to the next slide, that actually has the list of what we're going to discuss. Perfect, thank you. We're going to go over an overview of the 363 sale process. We're going to discuss the stalking horse bidder, the bid protections, the bid procedures order, and potential disputes. And finally, we will discuss the bid procedures. And with that, James, why don't you start us off with the overview of the 363 sale process?
Sure. Thank you, Evelyn, and good afternoon, everyone. So I think as most people on this call already know, Section 363 of the Bankruptcy Code governs sales of assets and actually use of assets. The Bankruptcy Code permits you to use assets in the ordinary course of business without having to go to court, but if you want to sell all of your assets, or substantially all, which is, I think, generally what we're talking about on this conference, then you are going to need a court order and permission to do that. And the first question is, what's really the standard under which the court reviews those kinds of requests? The answer in almost all circumstances is that it's a business judgment review, which is fairly deferential to the debtor. And in most cases, if you're proposing to do an auction, really that's a business judgment review of the procedures that the debtor is proposing to employ, and if there's a stalking horse bidder, the terms to bring in that stalking horse bidder. And that's really all that's being evaluated. So if you're going to try to fight that standard, which tends to not work, you're effectively going to court and saying, I know they want to do these procedures and they want to approve the stalking horse, but it's actually a not reasonable exercise of their business judgment to do that, and that's a fairly stiff burden to try to win as an objectant. Occasionally, you will see someone who seeks an order to sell an asset outside the ordinary course of business without having an auction. That's fairly rare, and there tends to need to be a fair amount of additional disclosure from the debtor and explanation as to why they're not doing an auction, which has just become so market standard that to deviate from it really requires a fair amount of explanation and facts to support why it just isn't going to work in that circumstance. Once in a while, you will see someone show up and make what's called a sub rosa plan argument to try to stop a sale of substantially all assets, where effectively the objector will say, really, you're just doing a plan. Why don't you do a plan and go through all the other cumbersome procedures that are required to do a plan? I think most people would tell you that nowadays that objection is almost always shot down. I think once, back a long time ago, it was much more of a successful type of objection you might bring. But at this point, it's effectively, it's an objection you can make. It's not an invalid objection, but it's you're making it more to be a nuisance than you are in any hope that it's actually going to win. So in terms of the benefits of a 363 sale, for the buyer, the big key benefit, I think, is that you get the cleanest title you can possibly get to assets under American law. And that's because, unlike any other type of asset sale you might do, you get a court order that says exactly what you're buying and that it's free and clear of liens, and it's free and clear of lots of other kinds of claims as well. And if there's any disputes about what it is that you bought, you often can go back to that same bankruptcy court and ask them to resolve those disputes and enforce their order. Other advantages are that you can take assignment of contracts, including contracts, some contracts at least, that wouldn't allow you to assign them by their terms. The bankruptcy code under 365 will allow you to break through a lot of those kinds of restrictions and assign the contract anyway, as long as you can satisfy the generally meetable standards of the bankruptcy code for assigning a contract. You get an expedited review of the process. And so if someone wants to try to drag it out with you by raising various issues, you can come before the bankruptcy court and you tend to be able to resolve those issues on an accelerated basis. You're able to, in some cases, get language in your sale order that allows you to limit or at least limit your successor liability and potentially some other kinds of liabilities that otherwise you might not be able to resolve outside of court. And then finally, as we mentioned, it's very typical that you have an auction process. And so from the debtor's perspective, it's very favorable, I think, to them to be able to sell an asset through this kind of very public auction where the buyers can all show up knowing that there's going to be one sale, the sale is going to happen. If they have a dispute, they can come before the bankruptcy court and they can feel very comfortable with what it is that they're buying. In terms of the disadvantages, I think, Lisa, you were going to address that?
Sure, and obviously for all the benefits, there are disadvantages to the 363 process, both for the debtors as well as the potential buyer. I think the first one that people recognize is that there is a disadvantage to having to go through the 363 process from a timing and cost perspective. In general, a sale outside of the bankruptcy code or the bankruptcy process is usually going to be faster and cheaper, for both sides of the agreement there. With respect to an additional disadvantage for the buyer, they generally have diminished control over the process because, as James went through, you have to go through this entire court-administered process subject to various different code provisions, and you do have to subject yourself to the market test. That also leads to a disadvantage for the buyer in terms of there being a competitive environment. There may very well be competing bids, and the stalking horse may not prevail at the end of the day. So that's certainly a disadvantage as opposed to simply a private sale outside of BK. For the debtors, there's also a heightened scrutiny, and there's this public process that you have to go through. So in some circumstances, a sale outside of BK would avoid negative effects of the bankruptcy filing on a debtor's business operation. And another potential disadvantage, something to think about anyway for a buyer, is that under some circumstances, a plan of reorganization may be more flexible. And notwithstanding those stringent plan confirmation requirements, purchasing assets through a plan may give a buyer greater flexibility than the 363 purchase due to the potential, at least, to leverage some favorable plan terms. And as James touched on, there is a two-part court approval process here. Step one, you have to go in and get those bidding procedures approved. That's not the end of it, though. Those bidding procedures just allow you to then proceed with the marketing and sale process that you set forth in those procedures. After you get through your auction, you have to go back to the court and then get that sale itself approved. So two different orders, two different opportunities for other parties to come in and raise disputes and try to slow down or derail your process. Evelyn, why don't you tell us about how long the process may take and how it works?
Sure. So there is nothing specifically in the bankruptcy code that controls the length of the sale process. I think normally you see sale processes running from about 45 to 90 days from the petition date to the sale hearing. In very, very rare cases, you may see something as quick as 30 days, but that really is the exception to the rule. And I think in those situations, you really have to have a strong justification for why it needs to go so fast. Examples that I could think of are maybe some type of seasonal product, or there's a very short shelf life for the assets, or even a safety issue that requires the sale to be done, as quickly as possible. I think the biggest factor in setting the timeline is the pre-marketing efforts that occurred before the bankruptcy has been filed. If there has been substantial marketing before the case was filed, then that often supports a shorter marketing period during the bankruptcy. Another factor that courts will consider is the complexity of the assets that are being sold. And then obviously there can be other extenuating factors, such as, for example, if there's regulatory approvals that need to be obtained before the sale can close, that obviously could also affect the timeline. In terms of a general overview, normally what happens is you file your case, and the Stalking Horse APA has either been executed right before the bankruptcy was filed or gets signed up immediately thereafter. Often you see debtors on the first day of the case filing the joint bidding procedures sale motion and asking for that motion to be heard on shortened notice. Here in Delaware, the courts are very uncomfortable having the bidding procedures approved before the committee is formed. And so while they will shorten notice, they want to give the committee a chance to, have their say on those procedures. And so they're looking to schedule that hearing, shortly after the committee has been formed. So the committee is formed, and then, you have your bidding procedures hearing. Again, there's nothing in the bankruptcy code that actually requires the bidding procedures or the court approval of the bidding procedures. And here in Delaware, it's almost always expected that the bidding procedures will be filed by the debtor and will be approved by the court. There is a very interesting case here in Delaware in front of Judge Walrath back in 2010. The name of the case was American Safety Razor. And there, the debtors did not go and get their bidding procedures approved in advance of the sale hearing, and it led to a lot of problems. So what happened there was that you had a secured lender, and you had unsecured trade debt and unsecured bond debt. And the secured lender agreed to credit bid, and they agreed to assume all of the trade debt in full, but there would be no recovery to the unsecured bondholders. They filed a motion to approve their sale. As I said, they did not seek the court's approval of the bid procedures. There was no bid procedures hearing. The bondholders found an alternative purchaser who was a direct competitor of the debtor. That alternative purchaser was willing to not only match the secured lender's bid, but was willing to pay 50 cents on the dollar to the bondholders. So obviously on its face, it was the higher offer. The debtors refused to qualify the alternative bidder as a qualified bidder under their bid procedures. They did have their own bid procedures. They just hadn't been approved by anybody because they didn't think that the alternative bidder would be able to consummate the transaction. And the reason for their belief was because they were a direct competitor. They were worried about antitrust concerns from regulators. The alternative purchaser argued that the debtor's decision to not allow them to bid on the assets was because debtor's management was concerned that the top executives would lose their jobs if the company was taken over by a competitor. So basically, they all showed up at the sale hearing, which turned into a several-day contested hearing. Judge Walrath took real issue with the fact that she had not been asked to previously approve the bid procedures in advance, and that no notice had been given to any other parties of what the procedures would be so that they could object to those procedures before they were applied. And she ruled that the bid procedures established by the debtors were not usual procedures, and she rejected the debtors' argument that the procedures were based on their business judgment. And I'm going to quote, because she did not agree that the procedures were based on a business judgment standard. And she said, and I quote, "The bankruptcy code and the rules and the process under the bankruptcy code are all matters for the court's determination as to what is fair and reasonable. In fact, I think that's my only role in this case, to determine what is fair for all of the parties." And she raised real serious concerns about the fact that nobody had come to her and asked for her pre-approval of the bidding procedures. And I'll just quote one more sentence. She says, quote, "I won't make any rulings on anybody's motivations other than to caution both sides, including the bidder, that there are sanctions that are available to me, and quite frankly, there are criminal sanctions for anybody who proceeds with a sale process in bankruptcy court for an ulterior and improper motive." And so again, I think this case really highlights the importance of getting your bidding procedures approved at your bidding procedures hearing. just to finish out kind of the rest of the timeline, after the bidding procedures hearing, you then have the marketing period, due diligence period, where the debtor and its professionals will go out and try to get other potential bidders and give them a chance to conduct their due diligence. They hopefully will then submit a bid by the bid deadline. Often debtors leave themselves a couple days between the bid deadline and the auction so that they have time to review the bids and determine if they're qualified bids, and they can work with bidders to try to make bids qualified bids if they've been submitted in a way that is not. You ultimately then have the auction, and we're going to discuss later in the presentation the different formats for an auction and kind of what happens in detail at the auction. Finally, you get to the sale hearing. It's normally very quickly from auction to sale hearing, just probably a day or two. It's at the sale hearing that the court will actually approve the sale. And then the last step is obviously closing of the sale, and that's governed by the closing conditions in the asset purchase agreement. Some buyers will want to wait the 14-day appeal period before being willing to close on the sale. Sale orders often contain language that allows the sale to close immediately, notwithstanding this 14-day appeal period, and people will do that to try to immediately close and moot any appeal by any other parties in interest. So that's the general timeline, which then brings us to understanding more about the stalking horse bidder, and James, you were going to address that.
Yep, thank you. So stalking horse is actually not a really great term for describing what this is. What it is it's a bidder that is already locked in with a signed asset purchase agreement at a fixed purchase price, and that is setting a floor so that you can guarantee that a sale will occur, and you try to establish a floor price that other people are going to have to beat in order to spur additional bids. The term stalking horse isn't a good term, because I think what this term actually means is it's a term from hunting, where it's a horse that the hunter literally hides behind while it stalks whatever it is that it's trying to shoot, and then you jump out and shoot it. And that's the idea that you're hiding behind something and then you're going to jump out and surprise them is really the reverse of what a stalking horse bidder does. A stalking horse bidder has their deal publicly shown to everyone, typically on the first day of the case, because the APA will be filed on the docket and everyone can see it. So it's really the reverse of what an actual stalking horse is. But in any case, everyone calls it a stalking horse. It is typical in bankruptcy, particularly for large transactions, for there to be a stalking horse buyer, but it's not actually required. You can just file a motion to set up procedures and have an auction without having a stalking horse, and then that's typically referred to as just doing a naked auction. The debtor is going to almost always want to have a stalking horse. The reason is, number one, to set that price floor that I talked about earlier, but I think it's really more motivated by a desire to make sure that there is going to be a sale that gets consummated. Even if nobody else shows up, you've got at least one buyer on the hook, and you can consummate the sale. You can get at least some proceeds for the assets, and you can avoid having a failed bankruptcy case. If you try to have a naked auction and then no one shows up, you may end up with a conversion and an administratively insolvent case, which leads to the worst possible consequence that can ever occur in bankruptcy, that debtor's counsel doesn't get paid. The advantages to the stalking horse of being the stalking horse are really, I think, divided into two categories. One is there's a financial incentive to be the stalking horse, which is typically in the form of a breakup fee and expense reimbursement. I think we're going to talk somewhat more about those in a minute, but just briefly, a breakup fee is essentially a fee you get for having agreed to be the stalking horse if you don't win the asset. And an expense reimbursement is similar to a breakup fee, except it's really supposed to be covering the costs you incurred in trying to be the stalking horse. The control aspect, I think, is more interesting, because being the stalking horse allows you to engage in a negotiation with the company, generally pre-bankruptcy, about what the structure of the sale and the bid procedures and everything we're going to discuss today is going to be, timing, all those kinds of things. And what you can do is you can try to use your leverage, depending on how much leverage you have as a stalking horse, to influence those procedures to make them more favorable to you and less favorable to anyone else who may try to show up and bid for the asset. The big disadvantage of being the stalking horse is that everyone gets to see your entire deal. And that doesn't mean just what you're offering to pay. They get to see your entire asset purchase agreement and all the things that go with it. And if you lose, everything, the fact that you were the initial bidder and then you didn't win is going to be very public. And the other thing is they're going to have to make your entire deal public before they know whether or not you're going to get to be the stalking horse and you're going to get your breakup fee and expense reimbursement improved, because it all gets filed, and then you go and have a bid procedures hearing, and the court either does or does not approve you. Now, most of the time, people do get approved, but there are occasions where people don't get approved. Lisa, I thought you had an example of a situation where a stalking horse actually got rejected.
Well, it was a little bit more nuanced than that. It was a situation in which we ended up with two different stalking horses over the course of getting our bidding procedures order entered. We had started off with having a particular stalking horse lined up in this case, and obviously that party came in and they put forward their minimum purchase price, and we urged them to raise that price because we had some serious concerns based upon feedback that we were getting from certain of our lenders in the case that floor was not going to be sufficient. They weren't interested in doing that, so we went ahead and filed the bidding procedures motion seeking to have that APA approved. But while we went through the process then of various different hearings and negotiations with our lenders, we continued in negotiations with that first proposed stalking horse to try to get them to raise their purchase price. And at the same time, our investment banker was talking to other potential bidders that we thought might be interested at a potential auction down the road. And one of those bidders quickly came to the forefront and said, look, I'd like to step in and be your stalking horse. I see that you guys don't have your procedures entered and that original APA approved yet, so I'd like to step in and I'm willing to up that floor by about another $5 million. And we said, okay, well, that's good to know. So we very quickly then worked with that new potential stalking horse to enter into a new APA that was substantially along the same terms, but still a little bit different, and then filed an amended motion seeking to approve bid procedures with that new stalking horse, and that was indeed then the one that was approved and the one that we proceeded with the court. So in that case, that original stalking horse found it in the unfortunate position of being bounced before even having its APA and the related bidding procedures approved by the court.
Right. So I guess my point is just that you take some risk in being the stalking horse, that you've gone to all this work, you put out your deal publicly, and then, as Lisa just indicated, you can sometimes get shot out of the saddle, and you did all that work to some extent for nothing. You still obviously can participate at the auction, and you've done a bunch of diligence, and that will still benefit you at the auction, but you haven't really gotten the benefits you thought you were going to get. So I think the next topic is we're going to start talking about bid protections. So the next slide. Is that you, Lisa?
Sure. So to James's point, one of the big advantages, aside from control, of being the stalking horse bidder is that you do get to negotiate certain things for your own benefit. And those are generally what we refer to as bid protections. And those are certain things that the stalking horse can demand as its incentive for being willing to be the one with that open public deal to set the floor. And the first place where you can go to look for those bid protections is right within the terms of the stalking horse asset purchase agreement itself. And that will be the first place that those show up, because that is the evidence of the underlying negotiations between the debtor and the stalking horse as to what the estate thinks that it can do and that the court will be willing to approve in terms of protections, benefits for the stalking horse. Those terms in the stalking horse APA are then directly incorporated, in some cases as easy as a cut and paste, maybe a little fancier than that, into the bidding procedures order and the underlying bidding procedures themselves. So those protections go out on notice, black and white, front and center, to everyone who's interested in looking at what the terms of this particular deal may be. In terms of types of different bid protections, James had touched on one of them that I think comes to mind most quickly for all of us, which is the money that a stalking horse can get in terms of a breakup fee and expense reimbursement. So the breakup fee is really the financial incentive for that stalking horse to set the floor. It provides a mechanism whereby the stalking horse can be not even reimbursed, but instead provided with funds in the event that that stalking horse is not the prevailing bidder and doesn't close on the assets. But you have to be careful when you're negotiating that breakup fee, both of the estate and of the stalking horse, because courts will look at that carefully. Is it reasonable under the circumstances? What has the stalking horse done? What are they bringing to the table? And in most jurisdictions, you'll find that the case law provides a certain range, a percentage range of the deal price that courts are going to be willing to say, yeah, under the circumstances in general, that's going to be reasonable. In terms of the expense reimbursement, what a stalking horse can get there will be the fees and expenses of its legal and financial advisors, for example, or costs that it incurred in undergoing and performing that original due diligence ahead of entering into the stalking horse asset purchase agreement. And those expense reimbursements, you can sometimes see that they will be capped either at a maximum amount overall or a certain percentage of whatever the purchase price was. And often in my experience, when you're dealing with these types of financial remunerations with stalking horse, the breakup fee and the expense reimbursement, you'll see the UST's office will be actively also looking at those and letting you know if they had issue with either the specific terms, the amount, or the circumstances under which the stalking horse may be entitled. Because there's room for disputes over these terms as to, okay, well, it seems obvious that if there is a different highest and best offer and the stalking horse doesn't prevail at auction, that the stalking horse will be entitled to its breakup fee and expense reimbursement. But what about if for whatever reason the case converts ahead of close? Is the stalking horse entitled to something under those circumstances? Maybe, but again, maybe that needs to be specifically provided for. The expense reimbursement is generally going to be specifically laid out that it will be an administrative expense claim against the estate, and under some circumstances, the stalking horse may try to negotiate its expense reimbursement as a carve-out even from proceeds that a secured lender may take at close. Evelyn, what other kind of bid protections might we see?
Actually, so before we turn to that, because I know you were speaking, you probably didn't see that you actually had a question. One of the listeners wanted to go back to that case you were talking about a minute ago and wanted to know when the second stalking horse ousted the first, did the bankruptcy court approve bid protections for the second stalking horse?
Great question. And the answer is a yes, but. So in that case, our second stalking horse, came in and they wanted to adjust the bid protections that the first stalking horse had requested. What they did is they wanted to readjust the amount that went to breakup fee versus overbid. And the total amount that they got in terms of that financial consideration for those bid protections ended up being about $250,000 more than what the first stalking horse ever had requested. And what the judge in that case did is she said, well, you know what, I understand the wanting to shift the amount from overbid to breakup fee. And while I don't love that, I understand it, but you need to agree that your total bid protections, second stalking horse, will not exceed those that were requested by the underlying stalking horse. So our second stalking horse, the one that did then get approved, had to agree to lower its overbid request so that it didn't exceed the total amount that the first stalking horse had requested. And that's just another example of how these things are negotiated. And sometimes the courts can come in, and even where you have a debtor and stalking horse in agreement, the court itself may say that you need to make some adjustments.
Okay, thanks, Lisa. So then, turning back to the other types of bid protections, another key bid protection is the timing milestone. Often, the stalking horse purchaser may serve also as the dip lender. And so wearing the dip lender hat, the stalking horse dip lender wants to have the process move quickly in order to conserve funds, and therefore we're pushing to have a very condensed timeline. And those milestones will therefore be baked both into the bidding procedures order as the stalking horse, but also into the dip financing order and dip financing agreement as default if those timelines are not maintained. Even when the stalking horse is not the dip lender, the timing milestones allow the stalking horse to control the process, right? They want, for example, the stalking horse, you want to control how much time will there be for marketing so that other potential bidders may not come out of the woodwork. How much time will they have to do due diligence? When will bids be due? Obviously, as a stalking horse, you kind of want to move the process along in the hope that at the end of the day, you're going to get to acquire these assets. And this obviously has to be weighed against what the debtor, the committee, the U.S. trustee, and other parties are trying to accomplish through this 363 sale, which is to maximize value for the estate. And so there'll be that pull and push of kind of what's reasonable in terms of those, milestones as you're setting those up in the case. Also, another bid protection for the stalking horse is the no shop clause, which basically prohibits the debtors and its professionals from going out and seeking to find other potential buyers. When I'm representing a buyer, I kind of think of it as 3 time periods. The first time period is the signing to the petition date. And as I talked about earlier, sometimes you're signing that stalking horse APA right as you're filing or right after you're filing. But other times you may be signing that stalking horse APA days, if not weeks, before the company is going to file for bankruptcy. Obviously, if I'm the stalking horse, I would prefer for the debtors to not be marketing during that time period until the bankruptcy is filed, and then they're going to have to. Obviously, the debtor is going to want to push back on that and say, no, we want to use the time leading up to the bankruptcy to market so that we can get into bankruptcy and tell the court we've been doing all of this marketing. But that's that first time period, whether or not the debtor will be allowed to market from the signing to the petition date. Then once the case is filed, as the stalking horse, and the debtor understand, now there has to be marketing, right? That's what's required to maximize value. The debtor is going to go out and market the asset. From the closing of the auction to the sale hearing, however, if I'm the successful bidder, again, I want to make sure at that point that the debtor can't be going around and trying to cut other deals. Once I've come to the auction, I've put in the time and money, and I've been declared the successful bidder. And so I want to make sure that the procedures are going to say, from the close of the auction to the sale hearing, there can't be any more efforts by the debtors to, get someone else to buy the asset. James, you want to take the next 2?
Sure. So the next one is representations versus due diligence. In a regular asset purchase agreement out of, in a non-distress scenario, it's, typically the buyer will do a lot of diligence about the company, and then a lot of diligence will effectively end up being baked into what can become a very large part of the asset purchase agreement, dealing with representations that can get extremely detailed, where the seller is making all kinds of detailed representations about what they are and aren't doing and the extent of those things. This can be a perfectly fine way of dealing with diligence and a deal between 2 solvent companies. It's not so great of a way of dealing with it in the bankruptcy context. And what's far more common is for you to get not very much in terms of representations from the debtor-seller, and to get more of an as-is, where-is in terms of the sale of the assets, and for the debtor to tell you, look, just come in and do your diligence, and you can ask and look at whatever you want to look at, but I'm not going to make a lot of representations for you that you can use to try to walk away from the deal. The debtor's concern there being that they don't want to give the buyer a lot of outs if they later on decide that they don't like the deal they signed up. The other thing that I think, though, that people sometimes lose track of, but that I think stalking horses in particular should pay attention to, is if you're the buyer, if you don't leave a certain amount of the purchase price in a reserve, having a bunch of reps that you can sue the debtor's estate about later on is not going to be a particularly helpful remedy for that long. The debtor's likely to blow out a lot of the money, or maybe all of it, to secured creditors pretty quickly. And then you may be left with reps against either an estate that doesn't have much left in it, and or the debtor may fold up tent, liquidate the estate, and be gone. And there's not anybody for you to sue. So it's not like buying a division from General Electric where you can feel comfortable that you're always going to be able to go back and sue on your reps. There may well be no one there for you to sue over. The other thing is that if you're the stalking horse and you put in a lot of diligence through representations in your asset purchase agreement, everyone else gets to see that asset purchase agreement. If you, on the other hand, do all your diligence yourself and you just have a very detailed diligence memo, you don't have to share that with anybody. Everybody else has to come in and do diligence themselves. And so one way that you can try to tilt the scales in your favor as a stalking horse is to do a lot of diligence, do an APA that has relatively few reps, and then try to narrow down the amount of time that there's going to be during the case between filing date and when the auction is supposed to happen, to try to make it kind of difficult on anybody else to come in and really do all the diligence that you did, which gives you a leg up on everybody else. So the other thing I want to touch on is credit bids, which are, depending on your perspective, a very important right of a secured creditor or a really great way to screw up the economics of an auction. 363K of the Bankruptcy Code gives secured creditors the right to credit bid for assets on which they have a lien, although there is an exception where the Bankruptcy Court can take that away for cause. We're going to talk about that in a little bit more detail in a minute, but I will just note that one of the things that you can have disputes about is whether or not the person who's credit bidding really does have a lien on everything they're trying to buy with the credit bid. And sometimes you can have the lender as the stalking horse through a credit bid stalking horse, and that can lead to a number of sort of interesting economic problems where you have buyers that are thinking, should I bid for this? Should I bid cash for this asset? Or should I just go and talk to the bank and see if I can buy their paper, potentially at a discount to the dollar, and then I'll be able to credit bid, and if let's say I buy paper that's worth nominally 40, but I only pay 20 for it, now I can make sure that I'm going to be able to take the company and can bid up to 40 million with, funny paper that I only bought for 20. So we'll talk about that, I guess, a little bit more in a minute. I think Lisa was going to talk about qualified bid and deposit requirements.
Yeah, just a very high level in terms of a few other bid protections that we can talk about in greater detail when we get into the nitty-gritty of the procedures. You'll also see that a stalking horse can negotiate very detailed provisions regarding what constitutes a qualified bid. What do qualified bidders have to provide in terms of information, due diligence, and also deposits? You'll also see negotiations where stalking horses will want to put in protections with respect to overbids, both a minimum initial overbid, that hurdle that your next bidder has to get over, which can be pretty substantial, as well as then further subsequent overbids. And you'll also see, just in general, depending on the case, where a stalking horse can include lots of good additional favorable stuff because they have that leverage, because the debtor wants to lock in a stalking horse. So just as a practice tip, if possible, some debtors may want to consider negotiating certain terms with your unsecured creditors committee or your secured lenders ahead of time. But to Evelyn's point, a lot of courts may not want to approve any bidding procedures, even if negotiated by the debtors and there's other parties in interest, until you actually have your stalking horse lined up. So it's just very case specific in terms of what protections may be in play. Evelyn, why don't you walk us through the bid procedures order itself?
Sure. So I'm going to cover now kind of in general, what the bid procedure order approves. And the first thing that it approves is notice of the auction and the sale hearing. And really, at the end of the day, what's key about this is service. It's who's going to get notice of the auction and the sale hearing. I've been in cases before where debtors' counsel has tried to argue that they only need to serve that notice on the 2002 list. I've assumed that it's probably a cost issue, that the debtor doesn't want to spend estate funds having to serve a large list. But when you're representing the buyer, at the end of the day, it's your client who's taking the risk if there is insufficient notice. And therefore, as a buyer's counsel, you want to make sure that that notice is served on as broad a group as possible. And the reason for that is case law is clear that known creditors must receive actual notice of the sale in order to be bound by the sale order's free and clear terms. And I think many people are probably familiar with the recent GM decision where the Second Circuit Court of Appeals rejected New GM's attempt to avoid liability that it thought it had purchased certain assets, free and clear. The problem was that old GM had known about these ignition switch defects and had failed to serve notice of the sale on those potential creditors. And so because that didn't happen, those people didn't necessarily know they had a claim, but the debtors knew they had a claim. Because that happened, New GM did not get those assets free and clear of those potential claims. And I think it's really important. I think the lesson from that case is if you're doing the due diligence for your clients or your client's doing the due diligence, you better make sure that what you're seeing in the data room, and hopefully it's in the data room, or if you're aware of it, you better make sure that you're then reviewing who's getting notice of the auction and sale hearing, because if they are actual creditors, you want to make sure that they're going to receive actual notice. Other parties you're going to want to make sure get notice are lien holders and contract and lease counterparties. governmental authorities, and litigation parties. In addition to actual notice, there's also publication notice, which the bid procedures order will approve. And that has to do with the fact that what case law says is if someone is an unknown creditor, then publication notice constitutes constructive notice, and therefore they are bound by the terms, the free and clear terms of the sale. So as a buyer, you're going to want to make sure that the debtors are definitely, going to publish notice of the auction and sale hearing. And as debtors counsel, I think it's important to think about where you're going to put that notice, because again, as debtors counsel, the goal is to, increase value, and therefore thinking about what kind of publications may result in additional bids. Do you put it in a certain type of trade journal? Do you put it in a local paper? You shouldn't just assume that you're going to want to put it in the Wall Street Journal or U.S. News Today. Additionally, the bid procedures order will approve the Stalking Horse bid, and it will approve the breakup fee and expense reimbursement, and we're going to talk in a few minutes about the types of fights that go on at the bid procedures hearing over approval of that. And it will approve kind of the general timeline that we've been talking about. And I think one very important practice pointer is if you've gone through the motion and kind of written down the timeline that's being proposed, it is very important that you go back and review the final documents that the court approves, the order and the bidding procedures, to make sure that you have the right dates and deadlines so you don't wind up missing something because you were relying on dates that may have changed. So with that, why don't we turn to some of the real disputes that get fought about at the bid procedures hearing. And James, why don't you go back and tell us a little bit more about credit bidding that I know you've been talking about earlier.
Sure. So credit bidding is a very common dispute. I think nowadays it's in vogue as a dispute that you might have at a bid procedures hearing. And I think one of the reasons for that is the proliferation of secured credit. So very often nowadays you have a company where the secured debt is well in excess of what anyone would think the value of the company is worth. And so there is at least, one or maybe a group of secured lenders hanging around that could easily just show up and credit bid their entire debt for the company, and should they do that at the auction, they're effectively no one's gonna bid more than them. So it creates a bunch of interesting incentives and situations. So one kind of dispute that you can see happen at a hearing, if you have a debtor that wants to set up a procedure to sell the asset and they do not want the bank to be coming in and credit bidding. One kind of dispute you can have is over whether or not there's a problem with the bank's liens. And so I think we're all familiar with it. Oftentimes a bankruptcy case will start with an investigation of the bank's liens, trying to determine if they really do have a lien on everything they think that they thought they did, and there's no problems with their liens and they're properly perfected and things like that. But these disputes, particularly if there's a quick bid procedures hearing because there needs to be a quick sale process, these disputes, which are often dealt with in a little more of a stately manner with the creditors committee kicking around for some investigation period, can get accelerated to where 20 days into the case you're now having to have effectively a full-out dispute about whether or not the bank's liens are or not valid, as you're trying to determine whether or not they're going to be approved or disapproved from credit bidding. There is this one example of a decision that I think almost everybody agrees is wrong, where called Fisker, which is Evelyn will talk maybe a little bit about it. It's out of Delaware, where the court effectively said, well, I think that if I allow someone to be here who can credit bid, then it's going to chill the bidding, and that's something that I'm going to use as cause to not allow the bank to bid. That case has a bunch of weird facts, but I think everybody basically accepts that case is not right, and that even in other jurisdictions that haven't directly addressed it, that you won't get away with just saying that it's going to chill the bidding. I think you have to say something more. But the fact that it will chill the bidding is something that people should think about as a real impact on the potential sale. So I've been involved in cases where the debtor's gone to the bank and effectively said, look, you need to set a floor price. You need to set a price at which, I know that you have a debt of 100. You need to set a floor price at which you agree you're not going to credit bid. That if someone comes in and bids cash at least 40, that you're not going to credit bid, or else no one's going to ever show up. No one's going to bother to put in the time. And sometimes you can persuade a secured lender on that, and sometimes you can't. The other risk of the secured creditor hanging around with the right to credit bid at an auction, which I sometimes like to do, is that it encourages potential buyers to think about, and maybe they can and can't do this under the NDAs that are signed up, but it encourages them to at least think about the possibility of going to the bank, trying to buy their paper at some discount, and then using that paper to buy the company, as opposed to properly participating in the auction process that the debtor is trying to run and funnel everyone through. And so it can create these bad incentives that can disrupt what you're trying to do in terms of an auction. Lisa, you were going to talk about you snuck something through in a 9019 once to resolve a credit bidding issue?
I wouldn't say that we snuck it through, and I'd say that the 9019 affected more than just that. This was a case that we were dealing with, and technically still are, over the summer here in Chicago, and it involved a large pool of lenders, as opposed to maybe your traditional case where you've got your secured lender with a blanket lien on all assets. We had a circumstance wherein we had one lender who was our day-to-day operations lender, who also had a first lien on a large pool of assets. But given what was at issue here was a large number of cranes and other equipment, we also had 15 other secured lenders with first position liens on 15 different pools of collateral. It was a tough case, tough process. So we came up with a procedure here where we not only had bidding procedures in play, but we created an opt-in, opt-out mechanism whereby those secured lenders could decide whether or not they wanted to opt in to the process that we had in place with the stalking horse we had brought in, who had set certain floors for each lender's collateral, or they could decide to opt out of our sale process, in which case they had whatever rights they otherwise had under the code. If they wanted to opt in, though, there were a couple ways that they could do so, and there were a couple things they agreed to do. If they wanted to opt in to our floor, to our auction, they had to first agree to pay a specific cost allocation for the administration of the auction, for our iBanker, for other professional fees, for just the cost of running this for their benefit. And they had to, if they wanted to, they could agree also to waive their right to credit bid. If they wanted to retain it, we baked in a mechanism by which we would set their credit bid without waiving any objections to claims down the road. But if they wanted to opt into this process with everything that was baked in, we included a specific provision into the order that said that with respect to those who opted in and wanted to pay that allocation, then the order itself and the terms of the procedures would constitute a settlement under 9019, with then the bidding procedures motion serving as the basis thereof, even though it wasn't specifically denominated as such. And that was approved. No one actually stood up and down and jumped on that. It was kind of nice to be able to go ahead and work that in. But I wanted to also go back to your lien question that you had raised, James, because we also had that come up in this case, where we had all these different lenders with different liens on the different pools. There were a few which had been identified, both by I'll call it our primary secured lender, as well as the committee, as potentially having issues with respect to their priority. So what we did is we also baked into our procedures a truncated challenge process. And obviously this wouldn't be a full determination prior to auction as to the priority of the liens, because that would have technically, I think, violated due process issues for some of our lenders, but we at least baked in a challenge process whereby we could do things on an expedited basis with respect to those specific liens that we had identified had priority issues, and then built in a mechanism whereby if those weren't addressed, funds could be held in escrow, or it could carry on then past the auction that we needed to get to on a much more expedited basis with the other collateral. So I think it's another example of how creative you can be with these bidding procedures on a case-by-case specific basis.
So now we're going to go back to talking a little bit about the breakup fee and the expense reimbursement. Lisa had talked about earlier about, every court being different about kind of what the courts will allow. Here in Delaware, the general rule of thumb is that combined, the breakup fee and the expense reimbursement have to be between 3 to 5%. There are exceptions. About 2 years ago, I represented one of the Stalking Horse bidders in the Hagen Supermarkets case, and we were able to convince the judge and the other parties that we should be allowed to go over that 5% rule by a little bit, because we had to due diligence hundreds and hundreds and hundreds of individual supermarkets. And so it was substantially more work than would normally be involved in doing due diligence in a bankruptcy sale but in general here it's 3 to 5%. I also last year was involved in the Philip Technologies case here in Delaware, which was in front of Judge Gross, and there were two interesting issues that we dealt with regarding the breakup fee and the expense reimbursement. My client was the Stalking Horse bidder, and the U.S. trustee objected that we should not get the expense reimbursement should not be approved because we had a due diligence out. And she also objected to what circumstances we should be entitled to be paid our expense reimbursement. And that second issue, at least erased some of the issues earlier about when exactly, do you get the expense reimbursement paid. Philip Technologies was a company that did GPS watches for children so that parents would be able to locate them. It specifically was targeted to like younger children, like middle-aged school kids. The case had to move very quickly because there were limited funds, and there were real concerns that if the company had to shut down, then kids could be, harmed. There could be jeopardy because their parents wouldn't know where they were, and they wouldn't have known why the phone or the app wasn't working. We, as the Stalking Horse, were working as quickly as we could to do our due diligence, but we were still getting critical documents from the debtors as close as a couple days before the bidding procedures hearing, and so we had not yet completed our own due diligence, which is why it was set up that we would have a due diligence out. The U.S. trustee argued that we shouldn't get the bid protections because there was no benefit to the estate. There wasn't a fully baked APA that was binding on us. She had concerns about confusion in the marketplace because of it, and she felt we were getting an unfair leg up. We argued that we did have an APA on file on the docket that other potential bidders could mark up, and the debtors actually said at the hearing that there were other parties conducting due diligence and they were working to mark up the APA that we had filed. We also argued that even though we had a due diligence out, we were required to make our final decision several business days before the bids were due, so parties and interests would know what the amount we were bidding was, and there would be a floor that would be set. We had the right, because we were still conducting our due diligence, we had the right to reduce the price of our bid if we wanted to continue to bid rather than just walk away, and we thought that was a benefit to the estate because it was better to have a lower bid than simply not bid at all. At the end of the day, we offered, and the court agreed with us, that we would lower our expense reimbursement if we lowered our sale price, again, to address that 3 to 5% rule in Delaware. And we also agreed that while the court would approve the expense reimbursement at the bidding procedures hearing, it would only become final once that due diligence period was complete and we were fully locked in. The other issue that was raised was when would we get our expense reimbursement. We argued that we should be entitled to it if the case was dismissed, if it was converted, or the sale did not close by a certain date. And our argument was that in all three situations, we were ready and willing to move forward with the deal, and therefore we should be entitled to our expense reimbursement. The U.S. trustee argued that if the sale didn't close, then there was no benefit to the estate, and therefore we should not get our expense reimbursement. Ultimately, Judge Gross said that this was a very unique case and that it was a tough decision for him, but at the end of the day, this case was really about concerns over safety of children, and that's why he ruled the way he ruled. In general, I don't think that courts will approve breakup fees and expense reimbursements where the APA is not fully signed, because you're not fully locked in at that point if you have some type of due diligence out. Also, courts here have expressed concern about pre-approval of those types of bid protections before there's actually an identified stalking horse. So those are kind of some of the disputes you see when dealing with breakup fees and expense reimbursement. The other issue that is often a dispute, and I talked about this a little earlier, is the actual timeline. And as we talked about earlier, the timeline is often very much dictated by the pre-marketing efforts that occurred before the case was filed. I think the practice pointer here to know is if you're debtor's counsel, it's really important before you file the case and before you set that timeline to have that heart-to-heart conversation with your investment banker so that you really understand how much time is needed, so that when you get to that bid procedures hearing and you're fighting over what the timeline should be and you're going to put your investment banker on the stand, you're going to have that support for why you need what you need. The other, I think, really important practice pointer is start telling your story to the court from the very first day hearing. If you know you need a certain timeline, tell the court. and tell the court if you have a shortened hearing on bid procedures, use every opportunity to make the argument so that by the time you get to that bid procedures hearing, it isn't the first time that the court's hearing why you need the timeline that you need. And just as a very quick example, this year my firm was debtor's counsel to a cancer lab testing facility. The biggest three things that we were selling were the employees, the customer relationships, and the brand name. And what we kept telling the court was, if we don't move the sale quickly, our employees are going to leave. If our employees leave, it's going to affect our ability to service our customers, which means we're going to lose our customers. And if we lose our customers, there goes our brand name. And therefore, Your Honor, we need to move as quickly as possible. And we repeated that theme as often as we could so that by the time we got to the bidding procedures hearing, the court was already well aware of why we needed to move as quickly as we did. At the end of the day, I think the issues regarding the timeline really are a case-by-case determination. You need to look at your facts. You need to look at what occurred before you filed for bankruptcy, and then you need to be able to explain to the judge why you're asking what you're asking for. So with that, James, do you want to talk about kind of specifically, now we're going to turn to what are the different requirements for bidding?
Sure. Lisa, did you have something you want to add about the timeline? You had an evidentiary hearing about it, and a fight with. It's always a fight with the UCC in my experience with the.
Yeah, just kind of layering over what Evelyn had talked about. We found ourselves in the position where, in this one particular case where we were dealing with, like I had said, the two different APAs negotiated in the Stalking Horses. Obviously, the court was well aware of what was going on, and we were in front of the court, it seemed like, every week there for a while. And so the actual timeline between when we filed the original motion to approve and when we found ourselves back in front of the court for the final hearing on the motion to approve the amended motion, about 6 weeks had passed, and then we wanted to move everything on a very expedited timeline in terms of date of entry of the order through to the auction, compressing it down to, I think it was maybe 29 days then, which is a little bit shorter than usual. And the UCC stood up and they were angry about the situation in general and raised an objection to this at the bid procedures hearing. Of course, it turns into an evidentiary hearing. We put our I-banker on the stand, and because, to Evelyn's point, we had been telling the court all along, look, we have this buyer lined up. We're trying to move it. We're having to push this out so that we're trying to negotiate with all of our various lenders. This is where we stand. This is the best we can do. We put our I-banker up there, and he was able to say, look, while maybe now we only have 29 days and another 3 weeks maybe to get those qualified bids in, we have already been marketing these assets for the last 3 months. We have already talked to all these different bidders. We have talked to all of these potential buyers. We've already funneled it down. We've done everything we would otherwise need to do. We don't think that any of these various parties that we have been in constant discussions with feel as though they're going to be in any way prejudiced by having what may appear on its face today to be a compressed timeline. And having had that history in front of the court, having the court see what we were doing and understand all of the work that had been done, certainly carried the day in terms of then getting court approval of the timeline that we had proposed.
All right. So in terms of bid procedures themselves, the first thing that I think you always see is, I actually think we're back on the slide right before this. We have this one long slide that I think we're still doing. So the first thing you see is you always see a bid deadline. That's the deadline by which anybody who wants to put in a qualified bid to compete with a Stalking Horse has to submit it. It always has to be in writing. It has to, basically, it's supposed to include an asset purchase agreement and everything else you would need signed, ready to go, such that if the debtor decided to accept the bid, they could basically just fill in their name and sign it, and that would be it. The question I think that just to note is, well, what happens if someone misses the deadline, but then shows up at the auction and they show up with, a large suitcase full of cash that they want to use to throw on the table to try to buy the asset? Technically that's not going to be in compliance with the bid procedures, but I think the practical reality is that it's highly likely that that person is going to end up being able to bid at the auction. I'm not going to guarantee it. I would never do that, but there's a good chance that after some disputes and some yelling and perhaps a call to chambers, that whoever it is showing up, if they show up at the auction with, the wherewithal to bid and they seem to be real, it's highly likely that the debtor is going to bend over backwards technically you are supposed to submit it by a bid deadline. Some of the protections you can ask for, you can get into squabbles over, what is going to be the initial overbid amount versus, what are going to be the bid amounts at the auction. If the Stalking Horse can try to bake it in to where these things are controlled in the bidding procedures, that is to fix the amount that an initial bid has to be in order to be a qualified bid. So, for example, if the Stalking Horse is bidding 30, you could fix that the initial bid has to be at least 32. And then it's not atypical for bid procedures to impose some structure on how much the bid increments can be to, and on the one hand, to prevent people from doing annoying things like bidding $1 more than the next person because it isn't the price is right, and to keep the auction moving. But on the other hand, the debtor normally wants to maintain at least some flexibility to control, what the bid increments are, so that if you start at increments of $1 million and then that sort of peters out, the debtor may want to allow increments in smaller amounts to try to squeeze out the last little money that they can. Another issue that is typically addressed in the bid procedures is if you make a bid, how long are you stuck with your bid? The debtor is always going to want that to last at least some period of days so that they can make sure, one, that they can lock in the bid and try to get to closing, and two, because of most debtors will want to insist that people who participate in the auction have effectively de facto agreed by showing up that they will be a backup bidder. And what that means is that if you finish number 2 in the bidding process, that you effectively are frozen, including your deposit that you put down is frozen for a while, as the debtor tries to go and close with number 1. And then if number 1 leaves them at the altar for some reason, they're going to want to be able to turn around and marry you instead. And so you end up being frozen for a while. Now, most bidders don't really want to be a backup bidder, and so the way the debtor gets people to do it is they try to force the Stalking Horse to do it, and then they say that anybody else who wants to participate just has to agree as well. That being said, I will note that I have seen circumstances in which the Stalking Horse tries to put into the bidding procedures that the Stalking Horse will not be the backup bidder under any circumstance, but that everybody else has to agree that they will. This is just another example of Stalking Horses trying to use their leverage to make it just a little bit less favorable for anybody else who comes in and tries to compete with them. In terms of the consideration that you see at auctions, cash is king. The nice thing about cash is you know what it is and you know how much it's worth, and there's really no disputes about that. But I think that you do see auctions where other kinds of consideration are allowed. And I'll tick through some of them briefly, but the problem with all of them is that the debtor and its investment bankers end up in a situation of having to compare apples to oranges with bids. The debtor would vastly prefer for all the bids to be on effectively exactly the same terms, and for the only question to be at the auction how much cash someone is willing to pay, because that makes it very easy to determine which bid is the best. What the debtor doesn't want is when bids are on different terms and people are bidding with different kinds of consideration, and then they're being forced on the record, on the fly, to have to assign what they think the value to those different kinds of considerations might be. So examples of other consideration you might have is you might have a buyer that shows up and wants to use some of their stock to buy the asset. This isn't preferable from the estate's perspective, because if you're trying to make a distribution, effectively you're going to have to turn around and liquidate that stock. You might have a situation where the buyer wants to issue buyer paper. That is, the buyer wants to effectively pay for it with some notes that the buyer is going to agree to pay in the future. Another sort of form of that is a situation where you end up with an earnout, where the buyer agrees to buy the company, and then based on what the financial performance that's achieved over the next few years, some additional consideration may come to the estate. And then I think particularly for intellectual property, you can see circumstances. This is particularly in the, with the pharmaceutical products, you see this a lot, where the buyer will pay a certain amount of money up front, but they'll also agree to some kind of royalty, where if you have an early stage product that hasn't been approved for, use in humans, and it's in some sort of early stage of testing, then you might end up with a deal that is very common in the pharmaceutical space, where if certain milestones are met, or if they cross certain hurdles with the FDA or eventually get FDA approval, or they eventually sell up to a certain amount of it in a year, that there are additional royalty payments that come back to the estate. But the problem with all of these things is that you end up at the auction and then potentially with disputes at a sale hearing about what's the value of these things and, how should they be valued. That's the nice thing about cash, how much it's worth. Lisa, I think you're going to talk about deposits and some of these other bid protections.
Yeah, happy to. And, with respect to your statement that cash is king, if you're going cash, you can include the specific requirement that a qualified bid can't be conditioned on obtaining any financing or on the outcome of any diligence. So again, just to your point, try to get people to bring cash to the table. Another very common requirement for qualified bidders to show up as a qualified bidder is going to be that they will need to submit a marked up APA that's going to reflect any changes between the Stalking Horse APA and the qualified bidder APA, and those should be substantially similar and very obvious to folks that if there are differences, those are highlighted for anyone who has an interest in the auction. There's an interesting question there also in terms of if you have an auction that is only for all of the assets versus where you may have an auction where piecemeal bids are allowed. And then you'll need to work in provisions that will provide for a qualified bidder to simply provide an APA marked up to reflect that subset of assets. So you need to keep that in mind as well. With respect to deposits, this is another item that can be negotiated with your stalking horse to make sure that your qualified bidders have sufficient skin in the game, that they are in and they are planning on being a part of this, but at the same time, you don't want it so high that you're going to end up chilling bidding. You can provide that your qualified bidders must provide sufficient evidence that's going to demonstrate that they have the financial wherewithal to actually close on a sale should they be the prevailing bidder down the road. You can require your qualified bidders to do the same as your underlying stalking horse in terms of providing their list of contracts and leases that they may want the debtors to assume and assign to them, and provide additional proof that they can come up with the requisite adequate assurance of future performance under those contracts and leases to be assumed and assigned. Another requirement for qualified bidders is that they provide their certification of no collusion. And we'll touch on this a little bit later with respect to some disputes as to potential auction disputes, but you got to make sure that your qualified bidders haven't engaged in any collusion such that the sale could not then be approved down the road. And to that end, you can also require that they provide full disclosure of bidder identity and any relationship to the debtor and its principals or any insiders. And where you've got your stalking horse lined up, and that stalking horse may want to then later take on some of the existing management or employees of the debtors, it's appropriate that that stalking horse be required to disclose the material terms and conditions of any contemplated employment or consulting agreement with those professionals, but also make it clear that any other qualified bidders don't necessarily have to have those same deals with the underlying debtor management in order to be considered as a qualified bidder. Evelyn, we also see that there are certain auction formats and auction requirements that are set forth in the bid procedures. What kind of things do we often see there?
Thanks. So yeah, the first thing is obviously who's going to attend the auction. Obviously, you're going to have the debtors there and its advisors, the committee there and its advisors. One note of caution, if your client is interested in bidding on assets, make sure they bring a lawyer. A very quick story, years ago, we got a phone call on like a Friday afternoon right before Memorial Day weekend from somebody who's gone to a bankruptcy auction and won assets and was really excited because he thought he got a great deal, paid a little money and thought he was, kind of stealing the assets. Well, what he didn't understand was he'd picked up all the cure amounts, which were substantial. He didn't understand that certain assets were consigned goods and he wasn't actually buying them. Over the course of the holiday weekend, we wound up backing out from the deal. The debtors wound up closing with the backup bidder, but not surprisingly threatened to sue us, and we had to pay the debtors the difference between the backup bid and our original bid, plus amounts that it cost the debtors to kind of deal with us. So just a warning there. Additionally, you should look at your local rules to see who can attend the auction. Here in Delaware, by local rules, anyone can attend the auction. Often the way debtors counsel deals with that is requires some type of notice to the debtors before the auction so that the debtors know who is coming. And obviously that way, if there's a real concern over someone wanting to come, you can always, raise the issue with the court that way before the auction. In terms of the auction length, it's not uncommon for auctions to last hours and hours, all day, well into the night, sometimes even going multiple days, especially if you have multiple bidders or you have multiple groups of assets that people have to bid on separately. Just a general understanding, normally the auction starts off in kind of one large conference room where everyone is together, but quickly the parties are separated. And that's because the debtor and its advisors are running around trying to understand the bids, the value of the bids, trying to change bids, sometimes trying to bring bidders together if certain bidders are bidding on different assets and combining them together will make a stronger bid. But in general, the purpose of the auction and what the debtor is trying to do is use the time to increase bids and maximize value for the estate. James, do you want to talk about the auction on the record?
Sure. So auctions, I've never been to an auction that wasn't conducted on the record, but I think just for people who haven't gone to one of them, what that means, we should clarify what that means. The vast majority of what's going to happen at the auction is actually not going to be on the record. What happens on the record is that there'll be a court reporter there, and everyone will go on the record for a period of time in which the debtor will then typically make some statements. Other people may make some statements, and then there'll be some bidding. And then what quite often happens is that there's a pause in the bidding for some reason, and everyone will agree to go off the record. And then a very large period of time will pass where everyone goes to separate conference rooms, and there's a lot of shuttle diplomacy, and people are talking, and people are calling back to the home office, trying to get more authorization to bid, and they're reporting back, and they're getting more approvals. And then eventually everybody comes back into the main conference room, and you go back on the record. So what as Evelyn described, you could have an auction that lasts for 24 hours, and the on-the-record part of it could be like 2 hours. And, you wonder, like, well, what are you doing the rest of the time? And the answer is that there's all kinds of negotiations and phone calls and things like that that are happening off the record. And then everybody comes back on the record and very briefly reports about where they are. But that being said, it is important to have it on the record. And the advantage of having it on the record is that later on, if there's a dispute about what happened at the auction, at least some of it was on the record. And if you have a problem as a bidder with something that's going on in the auction, you have an opportunity on the record to bring up that issue and dispute whatever it is that you think shouldn't be going on, and then force the debtor and other parties to have to respond on the record at that time, and thus create a record for you to go back and start fighting about what happened in court at the sale hearing if that's what you want to do. I'll make a brief note that there are some jurisdictions that sometimes have auctions in court. I think that is unusual for most large auctions. Most large auctions happen in debtors' counsel's offices or potentially at the investment bankers' offices, typically in New York or someplace like that. But there are jurisdictions, and I happen to live in one of them in Massachusetts, where there's a tradition of having the auctions actually occur in court. The disadvantage of that is typically you can't take all day if you want to because the judges are going to be there. The advantage is that everybody shows up in court. Everything happens in front of the bench while the judge is standing right there. And so if there are any disputes, they get resolved immediately. And everyone tends to comport themselves with a much higher level of deportment and behavior than you might otherwise see at some of these auctions. We mentioned earlier about bidding increments. I think my experience is normally that bidding increments are to some extent set by the bidding procedures, but the debtors have at least some flexibility about trying to change them during the auction based on what's happening. I will note that most people think of an auction and they think of effectively like an open auction, open outcry, really, where the debtor says, well, I'm taking bids. Who wants to make a bid? And someone makes a bid, and then someone else makes a bid, and it just sort of anyone can bid when they want to. Everyone hears everyone else's bids, and the rounds of bidding just keep on going until no one wants to bid anymore. And whoever bid the most is the winner. That's fairly typical, but it doesn't have to be that way. And an example of things that you can see that I have seen are where you can end up with sealed bids. So I've seen both a situation where there was only one round sealed bids, which was something that was introduced at the auction, where I will say that my experience was that both of the bidders who had showed up at the auction were quite upset with us that we were telling them that that was how we were going to do it, but they didn't really have a choice. And while both of them loudly objected and said they were going to leave and that what we were doing was outrageous, they both eventually agreed that they were going to participate that way. And so what happened was both of them wrote down what they wanted to do on a piece of paper, They handed it in. We opened both pieces of paper and read them on the record, and the person who had bid more by a substantial margin, I will note, won. The other thing that I've seen is I've seen it where they started off with open outcry bidding for a certain amount of time, and then in order to try to get things moving, the debtors effectively called an audible and said, okay, we've got 4 or 5 bidders here. We don't seem to be going up that fast. We're going to have one round of sealed bid, and then whoever are the 2 highest sealed bids, you guys are going to go move on to another round of open outcry, but the other 3, the 3 lowest, are going to be eliminated. Again, there was a round of people loudly objecting, saying that this was outrageous, saying they were going to call the judge and saying they were going to leave. But the thing was that the bidding procedures allowed the debtors to do this. It did not specify that the auction had to be conducted in an open outcry manner. And so what I've taken away from this is that if I'm the stalking horse and I do not want this to happen to me, I put in the bidding procedures that it has to be by open outcry and that it cannot be done by sealed bid. So just something to watch out for. It's not that common, but it can be done to you. And if you're not expecting it and it happens, it can be a little bit of an ugly surprise. Evelyn, does it happen to you in Radio Shack or something similar to you happen in Radio Shack?
Correct, and I know we're running out of time, so I will keep the comments short about Radio Shack, but that is exactly what happened, that we had open bidding. Things had kind of slowed down the momentum, and the estate decided that the best way to try to maximize value is to announce that there would be one last round and it would be sealed bids, and that's what we did. And then ultimately one of the parties showed up at the sale hearing and said that that was not permitted under the procedures, and Judge Shannon disagreed because the procedure said that the debtors could do whatever was necessary to maximize value, and by doing the sealed bids, we had been able to substantially increase the amount that the estate was going to receive. The other thing that was also important in Radio Shack, and was I think the next comment on the slide, had to do with making sure that the auction is closed. After the auction was closed, that same party then tried to substantially increase its bid, and ultimately the court would not allow it. I think in Radio Shack it had a lot to do with the fact that the sale required substantial negotiations with the Attorney General regarding customer information that was being sold, and I think the judge understood that if you reopen the auction, that all that work was going to have to be started over, and so he didn't allow that. But in general, I think case law is clear that it's up to the court to decide whether or not to reopen an auction. Courts are going to consider if there's been a substantial increase in money, but that should not be the only factor that matters. Courts look to see if there's some type of flaw in the auction process that would support reopening the auction, and courts are obviously also going to be looking to the key parties in interest to see if they support reopening the auction. If all you really have is an increase in money, that's probably not necessarily enough, because at the end of the day, it's important that an auction is closed and there's finality, and people understand that by participating in that auction, at the end of the auction, it's over. But the best advice I can give is if you're representing a purchaser, make sure they close the record, because that'll make it harder for someone to try to show up later and now outbid you. We go to I think we're up to the last slide now. Lisa?
Sure. So that brings us to our last topic, which, as we are at an overtiming, we'll keep very brief. And that leads to disputes over bidding procedures that may arise at the auction itself. Just things to be aware of when sitting on either side of the table as to things you might have to fight off, or things that you might want to raise on behalf of your client as to issues that you may have. One of the most common is to some of what we just heard about in terms of changes that may be happening on the fly at your auction. What do your procedures provide in terms of how the debtors can take steps to modify those procedures at auction itself? How much flexibility is there? Can the debtors go from an open outcry to a sealed bid? What flexibility might the debtors have in terms of lowering what those minimum subsequent overbids may need to be in order to keep the auction going? So just look carefully at those procedures to determine how much flexibility you may have day of auction to modify them. Another dispute that may arise there at the auction goes to what James had talked about earlier in terms of where you have non-cash bids permitted, how do you value those? How do you make that determination on the fly at the auction? What is your highest and best offer? How do you factor in royalties or earnouts that someone may offer? How do you factor in a lender credit bidding? What if you have a stalking horse who is permitted to, quote, credit bid part of its bid protection? What if it can credit bid part of its breakup fee? These are all issues that can come up that you need to be aware of day of auction. You also need to be aware of a couple of the findings that a court will have to make at the sale hearing with respect to code provisions. So you may have disputes come up over good faith under 363M at the auction. And James, I think briefly you had said that this was one where you did have a dispute come up.
I'm aware of a case where they got up to make the good faith finding. They put on the witness from the purchaser. One of the questions was, do you know the principal from the seller? To which the guy said no. And then it came out about an hour or two later in the evidentiary hearing that he had stayed at the guy's house the last night, which, as you can imagine, the judge got somewhat upset and decided that he didn't think that person was terribly so credible at that point, and it blew the 363M finding. The judge did ultimately approve the sale, but he wouldn't make a 363M finding. I think it's clear why. And the point is just that if you lose your 363M finding, you as a buyer have just lost an enormous amount of protection that you could have had, where if you get the finding, you can close. And the law is pretty great in almost every circuit that it's going to be extremely difficult for them to take the asset back from you or make you pay more. And if you don't get that protection, you're highly vulnerable on appeal to having the entire thing reversed.
And then that brings us to our final dispute that we want to point out to our listeners, which is be on guard against 363N, which goes back to the collusion issues. You've got to make sure that you don't have any issues with respect to collusion at the auction. Make sure you've got your certifications. And to the extent you have potential bidders who want to team up to form some sort of a conglomerate to bid for some of the assets, make sure that your procedures allow you to do that, or that everyone is fully disclosing what's going on. So with that, thank you very much to everyone for listening, and we will turn it back over to Amy at the ABI.
Thank you so much. And thanks, Lisa, James, and Evelyn, for sharing your expertise with us today. This has been a very interesting panel. I've always found auctions and bidding procedures so interesting, and the dynamics that can be involved, and you all shared your experiences with us today, and we appreciate it. And thank you to the ABI Asset Sales Committee for hosting this webinar. As Evelyn mentioned earlier, if you are not a member of the committee but are interested in joining, membership is free to you as an ABI member. You can sign up for this or any other committee at committees.abi.org. And of course, if you're not an ABI member and are interested in joining or learning more, please visit abi.org and you can register there. For those of you needing CLE credit for the program, our CLE coordinator will send an email to you in 2 to 3 weeks with directions on how to obtain your CLE credit. Thank you again for attending our ABI Live webinar. Look for our next webinar on our website at abi.org, and have a great day.